Welcome to Planet Lex, the podcast of Northwestern Pritzker School of Law, bringing it to you from Chicago, Illinois.
Hello, and welcome to Northwestern Law's Planet Lex. I'm your host, Vice Dean Jim Speta. Today I'm joined by Emily Kadens, Professor of Law here at Northwestern. Emily, thanks for joining me.
Glad to be here.
In addition to her law degree, Emily has a PhD in medieval history. Emily's scholarship focuses on the medieval and early modern history of commercial law and practice. Among other areas, Emily has written on how custom does or does not function as law, the concept of the medieval law merchant, and the early history of English bankruptcy. Emily's article on the history of judicial education in England won the 2010 Sutherland Prize from the American Society of Legal Historians for the best paper in English legal history. And her article on an early 18th century bankruptcy scam won the 2011 Editor's Prize from the American Bankruptcy Law Journal. Her other work has appeared in the Columbia Law Review, the Duke Law Journal, and the Texas Law Review, among other places. Prior to teaching at Northwestern, Emily was the Baker and Botts Professor in Law at the University of Texas at Austin. She also clerked for the Honorable Danny J. Boggs on the U.S. Court of Appeals for the Sixth Circuit, and she held a Kluge Fellowship at the Library of Congress. In 2018, Emily was elected to the American Law Institute. Again, thrilled to have you here, Emily. Thank you very much.
Thrilled to be here.
Emily, you took a PhD in, as we said, medieval history and finished it before enrolling in law school. What drew you at that point to combine the enterprises of history and law?
I wasn't originally intending to combine the enterprises at all. While I loved history and enjoyed writing my dissertation, I realized halfway through the process that I didn't want to be irrelevant for the rest of my life. And I was writing on 13th century Flanders, and therefore I was going to be irrelevant for the rest of my life. So I went to law school thinking that I would do something relevant, and instead I ended up becoming a law professor, and I'm still writing history.
Now, we're relevant. We
Sure.
really are.
Sure. We get to train future lawyers. Maybe there's relevance to that.
Absolutely. When we talk about medieval and early modern history of commercial law, when and where are we talking about?
Generally speaking, medieval history in Europe runs from roughly 500 to 1500, or from 1000 to 1500 if you categorize it differently. And early modern history concerns the period from 1500 to 1800. I study European history, although right now my work is focused on England because that's where I've found some really wonderful sources.
And what are you working on now in England?
For the past few years, I have been studying the history of commercial fraud in England during the period of about 1570 to 1630. I became interested in fraud while writing on this mythical story called the Medieval Law Merchant, which some modern legal and economic scholars believe was a customary commercial law created by merchants in the Middle Ages. And part of the idea imports a theory that's important in economics, that merchants will behave honestly because if they cheated, they will get a bad reputation and they will lose their business. So there's this assumption that the medieval law merchant prevented cheating. So just to give you a great example that my research assistant pointed out to me, in the 1100 plus page 2-volume The Cambridge History of Capitalism that runs from ancient times to the present, the word or stem fraud is mentioned less than a dozen times. So fraud, it's just something that until very recently hasn't been on the radar screen of economic or legal historians. But the problem is that when I was looking at the medieval records, I saw all sorts of fraud. And I saw people getting caught for committing fraud and then still doing business in the same community. So luckily, I kind of stumbled into a wonderful set of material to use, namely the records of the English equity courts, which are kept in the National Archives in London. And equity courts, which particularly flourished in this period from the 16th to early 17th centuries, used a completely written procedure with very extensive pleadings, interrogatories, and depositions that served as the witness testimony for the court. And there's nothing comparable in the common law courts. So all I had to do was find actual fraud cases, and I'd have this really wonderful detailed evidence.
When you say the history of commercial fraud, as a lawyer, I think about the legal doctrine of fraud. And so what would be the history of the changes in rules, if there are any changes in the rules? Is that what you're looking at?
There's an element of that, but frankly, until the 19th century, there wasn't a whole lot of doctrine about fraud. It's just such a slippery topic. Even today, we have trouble deciding if somebody has committed a fraud. That slipperiness made it perfect for the equity courts, but they didn't have to limit themselves to ruling on questions of law. So they could do equity based on the facts of the case, but they didn't really have to develop a lot of legal doctrine. What I'm mostly interested in instead is the question of what kinds of fraud occurred. How did people cheat? What motivated or permitted them to cheat? And then what institutional structures, whether they're courts or statutes or contract mechanisms or private ordering, existed to try to control or punish this cheating? And to study this, as I said, I'm concentrating on evidence generated in court cases, primarily in the courts of Star Chamber, Chancery, and Exchequer, but also to a lesser extent, other less well-known courts like the Court of Requests and the Admiralty Court.
So the case we're going to talk about today, Twyne's case, was in one of those courts you just mentioned, specifically the Star Chamber. When we hear the court of the Star Chamber today, what at least I think of is torture and persecution. Is that what is going on in this case?
No, not at all. Until about the 1630s, actually, in the reign of Charles I, the Star Chamber was a useful and popular court that had jurisdiction over, among other things, official malfeasance, misbehaving juries, riot, and various forms of fraud, and in general, criminal misdemeanors. And also, by the way, the story that the Star Chamber engaged in torture is a myth. It did not. Now, on the other hand, the common law courts did, in some cases, engage in torture, but that's another subject.
So let's talk specifically about the article that you've just published on Twyne's case. It's in the American Bankruptcy Law Journal, and it's called New Light on Twyne's Case. This decision is a decision from England, as you say, from the Star Chamber in 1602. But as you write, it is one of the most important cases in United States commercial law. What's the case about?
Twyne's case is probably the oldest English case still actively being cited by American courts. I looked and checked on Westlaw last night, and it was most recently cited in 2019 by a bankruptcy court, and the U.S. Supreme Court, in fact, cited it in 2016. Twyne's case is about fraudulent conveyance, which classically occurs when a debtor transfers some or all of his assets to a third party with the intent to keep them from the debtor's creditors. Our modern law of fraudulent conveyance goes directly back to the statute of 13 Elizabeth of 1571, which forbade transfers made with the, quote, intent to hinder, delay, or defraud. And these are words that still appear in modern fraudulent transfer laws. So according to the version of Twyne's case cited in U.S. courts, which is the version that's in a report written by Edward Cook, who was the Attorney General who prosecuted the case, the facts are that Pierce owed Twyne and another creditor known only as C quite a bit of money. And after C brought suit against Pierce, Pierce secretly conveyed all his sheep to Twyne. And when the sheriff appeared to execute the writ, Twyne ordered his men to resist. And the sheriff then initiated a suit ex officio as Attorney General in the Star Chamber, and the case was heard in 1601. So that's the story.
So the Attorney General, Cook, brings the case because of the riot that happens.
Well, that's my argument. That isn't what you would get from the case itself. In fact, it's interesting. There's only one line in the case. It's the very last line that says, oh, and there was a riot. And that is a line that was not in Cook's manuscript version of his report. I actually have his notebook where he wrote out the report. It only appears in the published version. So what's important about this case is that Cook's report gave judges a test composed of 6 badges of fraud to evaluate when a transfer, even one made for good consideration, was done with the intent to defraud. And courts still cite the case for that test today. The problem, as I discovered when I dug up the actual case documents, is that pretty much all the facts as Cook relayed them, are partly or completely inaccurate. And this is very fortunate because the facts as Cook lays them out aren't terribly interesting, and that would never have struck me as the basis for an article.
If the case didn't seem interesting at first, what drew you in and what kept you going on it?
Honestly, I was suckered into it. In normal years, I spend much of the summer working in the archives in London. And a few years ago, I discovered the Star Chamber archives, and in particular, discovered a way to get into the virtually uncatalogued archives of the Elizabethan Star Chamber. And when my husband, who's a bankruptcy professor, found out about this, he begged me to look for the documents in Twyne's case because it's such a famous and important case in American bankruptcy law. So I found them. Well, initially I found some of them. All of the pleadings are lost, never found those. And most of the really interesting depositions were miscatalogued, so I only found those later. But when I found the original set of documents, I promised my husband we could co-author an article. And so then I started transcribing the material, and it turns out that the real story behind the case is very interesting. And I found a whole bunch more material, and I decided to write this article myself, and I would not let him co-author because I was like, this is way too much fun, and I'm not going to let you muck it up. And I want to keep it all for myself.
You mentioned just now that you were transcribing the materials, but they're from England, right? So what do you mean that you're transcribing the materials?
Well, they are actually Chancery Equity Court material is in English, but it's written in a hand that is very difficult to read. And it's something that you actually have to learn to do. And so it's not like I can pick up a manuscript, and just read it and just skim through it. I actually have to transcribe it onto the computer first before I really know what I've got.
So what did you get? What was this interesting story that you found?
Okay, there are so many details that I found. I'm going to try to be concise here. If somebody wants the full story, they're just going to have to read the article, which is very long. The events occurred in a small town in Hampshire, in England, called Whitchurch. It's a very small town. Around 1594, a local guy by the name of John Pierce, who was a pretty important guy in Whitchurch, married a rich widow named Margaret Clark. Margaret had received the long-term lease to Whitchurch Farm from her deceased husband. And Whitchurch Farm was huge. It was the biggest farm in the area. And for various reasons, Margaret had found it necessary sometime before 1594 to mortgage the lease to her neighbor, Henry Audley, who was a quite wealthy and fairly important guy in Hampshire. So sometime before November 1594, John marries Margaret, and he takes over the lease, and he takes over the debt to Audley. Unfortunately for him, he entered into this obligation at the start of the worst agricultural depression of the 16th century. So by 1596, he is in deep financial trouble, and he goes back to Audley to renegotiate the debt. They work out a new deal. Ultimately, Pierce was to repay Audley about £1,100 in 1600, so 4 years after. Now, that amount is about $284,000 today. Pierce's relatives, John Spencer and John Twyne, agreed to serve as sureties, but they didn't ask for any security.
So we've now mentioned Twyne, and this is called Twyne's case. So yep. Pierce owes money, and by being a surety, that means Twyne, if Pierce can't pay, Twyne is going to have to pay.
Yes, Twyne is fully liable. It's actually interesting that you point this out, that it's Twyne's case. It's something I talk about in the paper. It's Pierce's debt. And Pierce is the one that makes the fraudulent or the allegedly fraudulent conveyance. And yet it's always been known as Twyne's case. And I argue that's because Twyne is really the one who was taking the lead in the litigation. So, okay, this debt is taken on in 1596. It's due in 1600. And in 1599, Pierce realizes he's not going to be able to pay the debt. So he goes back to Twyne for help. And Twyne agrees to pay the debt to Audley if Pierce will give him, Twyne, all his livestock, grain, and household goods as consideration. So Pierce executes 2 deeds of conveyance to this effect. And Twyne does ultimately pay the debts to Audley. So there's good consideration for this contract. The first problem is that Twyne did not take possession of any of Pierce's property. So we have a transfer of title without transfer of possession. And that's something that Twyne's case came to stand for as being presumptively fraudulent. And the second problem is that Pierce might have made the transfers to Twyne only after Pierce had noticed that a creditor named Thomas Warburton had sued him for the money Pierce owed to him. So if that's the case, then Pierce had made knowingly a fraudulent conveyance to Twyne. But for that to be the case, it depends on a few other things. One, you have to believe that Pierce had the scrivener of the deeds backdate those deeds of conveyance because they were dated to a period before Warburton's suit. It also depends on whether you believe Warburton was a genuine creditor. I found lots of evidence of creditors suing Pierce. So if you just take that, there's a fraudulent conveyance, but they don't figure at all into this story. The court doesn't get any testimony from them, from all the rest of the creditors at all. But the thing is, I looked in the Common Pleas plea rolls, in the Common Pleas writ rolls. There is nothing about Warburton's suit. Nothing. And this absence is quite odd because I found all these other suits against Pierce. And there's a twist that I'm going to come back to at the end that involves Warburton. So the situation comes to a head on November 10th, 1600, when the undersheriff of Hampshire, Brian Chamberlain, shows up at Whitchurch Farm to execute Warburton's writ against Pierce. And Pierce's people, so Twyne, by the way, is in London, so he's got nothing to do with this. Pierce's people tried to convince Chamberlain that all the property on the farm actually belonged to Twyne. But Chamberlain wasn't buying this because it turns out that Twyne was a bit of a fraudulent transfer entrepreneur. He had done this trick before more than once, and Chamberlain knew it because he had tried to execute on someone else a couple of years earlier and had been rebuffed by Pierce and Twyne showing up with the deeds of conveyance. So November 10th, he's unsuccessful in executing. He stays the night at an inn in Whitchurch. And on November 11th, he tries to sneak out of this inn to execute on some cows that are pastured on a distant field called Holden Field. Now, this field still exists as a field.
When you say execute on some cows, what do you mean by that?
So he wants to seize the cows based on the legal right he has under the writ. He wants to seize the cows and sell them and then give the money to the creditor.
But Twyne says these aren't Pierce's cows. These are actually already my cows.
Well, Pierce's people say this. Pierce is hiding in his house for 3 days. He doesn't show up. And I think he's hiding in his house because he's afraid that there might be a writ of body execution against him, which would allow Chamberlain to drag him off to debtor's prison. And Twyne is in London. So Twyne's not involved. Now, Twyne may deliberately have not been involved, so he had cover, but Twyne was physically not there. So it's Pierce's men who are being clearly ordered around by Pierce or by Pierce's wife. So Chamberlain had snuck out of the inn to go to Holden Field. And the thing he didn't know is that the inn was owned by one of Margaret Pierce's sons. And so as soon as Chamberlain sneaks out, the inn holder sends a boy running to the farm, and it's about a 5-minute trip from the inn to the farm, to tell them what Chamberlain was doing. So Chamberlain's people get together, and they rush over to Holden Field, and they arrive just as Chamberlain and his men had driven the cows out onto the road, and a standoff ensues. There might at this point have been some violence. There are claims that Chamberlain, his men, Warburton are like beating up on the Pierce's men. In fact, Warburton is quoted as saying, "Mr. Sheriff, please, deputize me in the Queen's name so that I can participate in this beating." Well, but ultimately, after a certain amount of time, the parties calm down and they agree to drive the cows about a mile back into Whitchurch, where Chamberlain will assemble a local jury and they will adjudge whose cows these are. But when they arrive in town, Chamberlain reneges on his promise and he uses the local men to appraise the cows instead because he's just going to sell them. So the cows are pastured that night in Pole Meadow, which is a very low-lying meadow right across the River Test from the center of Whitchurch, and it also still exists. So somehow, and nobody will admit how in the depositions, very early in the morning, the cows get loose and they are wandering in the river. And this was a fact I could not figure out until last December when my husband and I went to Whitchurch. And we were shown all the key sites that happened in this story by this wonderful, wonderful local historian. It turns out that the River Test, at this point where it runs by Pole Meadow, is about 18 inches deep and about 15 feet wide. For the cows, it's like a drinking trough, right? So now I can understand why the cows are wandering in the river. About 6 a.m., Chamberlain and his men are trying to collect the cows from the river, and they were going to drive them out of town to sell them to somebody else. And Pierce's men show up, and a melee starts. And I'm going to quote one passage from the paper about this. So the quote is, and this is from the depositions, Walter Clark, that's Pierce's farm manager, engaged with Edward Hill, Chamberlain's assistant, who had his rapier in his hand, and, quote, quarreled with and reviled at Walter and called him rascal, saying he would have a bout with him. And then Walter responds that Hill was the, quote, rascal, and that it was best for him to leave his quarrels and to put up his weapon, or else he would make him put up his weapon. And then it might have chanced entirely by accident, of course, that Walter stuck his piked staff in Hill's buttocks, but certainly Walter believed without hurting him. So that's a taste of the paper.
Maybe rascal was a more severe insult in 1600.
It apparently was a very severe insult in the early 17th century. Yeah. So ultimately, Pierce's men drive the cows back to the farm. They drive it through the middle of town. Everybody comes out and they're watching this, and allegedly they're jeering at Chamberlain, who's like trailing along behind. Cows get back to the farm. Chamberlain sends for a justice of the peace, and with his help, he's able to complete the execution. He never actually takes possession of any of the property because he makes a deal with Henry Audley. Remember the neighbor? Audley had shown up to try to calm things down, and he makes a deal with Audley that Audley would pay the appraised value of the cows, the horses, and the grain that were seized. There were no sheep seized. And if the property proved to be Twyne's, in fact, Chamberlain would pay the money back to Audley. Unfortunately, Audley, at Twyne's instigation, never pays Chamberlain. And so Chamberlain, very soon thereafter, about a month later, acting as a relator, gets Cook, the Attorney General, to bring suit against Pierce and Twyne and all of Pierce's men who are accused of committing riot by their actions. The definition of riot at this period of time was very, very broad. I think, as we talked about earlier, that initially Cook was interested in this suit because of the alleged riot, because the late Elizabethan government was absolutely petrified of popular unrest. So ultimately, Twyne and Pierce lose. Cook uses this case to generate this new rule, this new interpretation of the Statute of 13 Elizabeth. But what's interesting is there's another wrinkle here, and that is that Twyne claims that the entire accusation of fraud made by Chamberlain was itself fraudulent, because he says that Chamberlain wasn't actually executing on real writs. He says he's working in cahoots with Warburton, his buddy. And he says the whole execution is a fake, and it's aimed at getting back at Twyne, not Pierce, because Twyne had discovered that Chamberlain, in his role as undersheriff, was cheating the crown on tax collections. And Twyne had threatened to reveal the scam. And because Chamberlain knew about Pierce's conveyance, he knew that if he took Pierce's property, he's really hurting Twyne. Now, I have no idea if this claim is true, but it does make the absence of evidence in the court rolls of Warburton's lawsuit way more suspicious.
That's really interesting. But on the main story, so Twyne and Pierce lose this case, right? And Cook's report says that the Court of Star Chamber finds this transaction where Pierce sells, quote unquote, sells the livestock and other goods to Twyne but Twyne doesn't take possession. The court finds that to be a fraudulent conveyance.
Yes.
Yeah. So as you've told the story, I feel like I'm living there with you in 1600, the way that you...
I did too, yeah.
The way that you know all the details. You said already that you made a trip to Whit Church. What else did you do to get all the pieces of the story together from a case that's now 420 years old?
So working in archives is a little bit like doing detective work, which is part of the reason I enjoy it so much. I started with a list of Star Chamber cases from the reign of Elizabeth. All this list shows is the names of the parties and the date of the bill. That got me a couple of initial documents from the case. And from there, once I knew the names of the various players involved, I was able to use some educated guesswork to identify the miscatalogued documents, cataloged under the wrong names. And then the text of those depositions that I found informed me that there were other related lawsuits in other courts, namely Exchequer, Chancery, and the Court of Requests. So that got me a lot of information that I could use to fill in the blanks of the fact that the Twyne's case pleadings are missing. I also searched, as I said, the Common Pleas plea rolls to look for entries indicating Warburton's lawsuit having been filed. And I searched the Common Pleas writ rolls looking for Warburton's lawsuit. The writ rolls are the single most disgusting thing I have ever used in the archives. They consist of hundreds, maybe even thousands in some cases, of writs, which are these long, thin strips of parchment about maybe 2 inches tall and about 8 or 10 inches wide. And they're strung together on a wire and they're packed really, really, really tightly. And then that pack is rolled up. And sometimes the ends of the writs, because they're parchment, they congeal together into this like big block. And in every case, when you pull it out of its box, its archival box, and you open it up, there's just all this dirt and debris rains down everywhere. I'd be like black from head to toe. It was gross.
I've seen some of the pictures you've shown me and some of the videos, and it does look like these old rolled up pieces of paper have been just covered with ages and ages of dirt, which I suppose is literally true about the conditions of the archives.
Yeah, they've basically haven't been looked at. There was an archivist who looked at them so he could catalog them a few years ago, but otherwise they really haven't been looked at in probably, in most cases, hundreds of years, and they're just disgusting.
So while I've seen the pictures, we can't share those with our listeners today, but you do have a recording of what it sounds like when you take this ancient paper and try to unroll it. Can we see if we can hear that here?
Yes, let's see if we can do that.
Do you worry when you handle these roles, or more importantly, do the archivists at the National Archives in London worry that the pieces of paper are just going to disintegrate in your hands?
No, it's important to remember they're not paper, they're parchment, and parchment is animal skin. And parchment, honest to God, would survive an atomic attack. You can smudge the ink if you take your hands and to rub it across the ink, and so they don't let you do that. But they don't make you wear gloves for using this old stuff. If you're using some modern stuff, sometimes that's so fragile, or if it's like photographs, that they make you wear gloves. But basically, what I understand their thinking to be is that if you wear gloves, you're clumsier, and therefore you're more likely to tear things than if you're just touching it with your regular hands.
And as you say, you're the first one maybe to have looked at them in 400 years, so they're just happy to have you there working on them.
Yes, maybe.
So let's come back to the article. You write that one of the important insights that you've taken from the story and from how the pieces of evidence that you've come together interact with Cook's report is a better understanding of how credit worked during this time period in the early 17th century. What is that insight?
So in the 1940s, Gerard Glenn published a treatise about fraudulent conveyances that's still referred to today. And concerning Pierce's conveyance to Twyne, he wrote that it was suspicious when Twyne, upon purchasing Pierce's sheep, did not drive them away as naturally he should have done. I thought, there's a problem with this assumption that this conveyance had to be fraudulent because there was no transfer of possession. Because what was Twyne going to do with 750 sheep, 16 horses, 60 cattle, and 60 hogs, which is what Pierce allegedly conveyed? The land at this point in time can only support so many animals, and the markets are only so elastic. So the other thing is, if Pierce conveyed away all of his assets, how does he run his farm and earn the rest of the money he owes to Twyne and to his other creditors? So what I came to decide is I think that what was going on here was a type of transfer of title without transfer of possession that's a kind of a chattel equivalent to a real property mortgage. Now, normally when you make a chattel mortgage, you have to transfer possession. But I think that this is a situation where you can't transfer the chattel. And what we are seeing is a sort of under-the-radar mechanism used in an immature credit economy in which there are no banks. And the thing is that the fraudulent transfer statute of 13 Elizabeth turns this into kind of definitionally a fraudulent conveyance. And the only time we would really hear about it is if it ends up being litigated. And so historians have just accepted that this is a fraudulent act, and they haven't recognized it as a potentially valid and non-fraudulent means of obtaining financing. I think of it a little bit as a debt consolidation mechanism. You give all your property to Twyne, property then pays off your debt, and then you just have to work with Twyne to work out the rest of the financing.
So in fact, the rule that Twyne ought to have taken possession from the perspective of the statute of 13 Elizabeth, as you call it, that perspective may not have actually represented what was best for both Twyne and Pierce. It may be that keeping all the livestock on Pierce's farm made those livestock more valuable to Twyne.
Exactly. It might have made it more valuable to Twyne, certainly made it more valuable to Pierce, made it more valuable to Pierce's other creditors. It probably was a better situation all around, provided it was not done with fraudulent intent. In other words, as long as Pierce is not doing it to cheat his other creditors, then it's fine. But the way that the rule, or the test in Twyne's case works, is you start from the presumption that it's fraudulent. And then you look for these other signs or badges of fraud that Cook comes up with. And you can look and you see all of these badges of fraud in Twyne's case. But you could also interpret them as, no, this is Pierce trying to consolidate his debt and not trying to cheat his other creditors, none of whom apparently sued him because of this.
So if that was the way this played out in 1600, that the transfer of title without the transfer of possession is presumptively fraudulent, is that still the law today?
It was the law in the common law for a really long time that if you took a mortgage on chattels, you had to take possession. But that's not what's going on anymore. So taking possession was the notice of the transaction. You didn't have a filing system. There's no fraud if people know that this is going on, if it's done openly, and if there's a change of possession. But UCC Article 9 in the 1960s consolidated a trend in modern non-possessory financing of personal property by taking the teeth out of the notice exception to Twyne. So today, for instance, banks take a contingent title to personal property by filing a one-page document called a financing statement, in which notice is met by the vaguest of descriptions, such as inventory or equipment or even all assets. And the Twyne court would have been appalled by this.
So if Twyne has been replaced in that regard, why is the Supreme Court and other bankruptcy courts still citing to this 400-year-old opinion?
Because of this badges of fraud jurisprudence. So Twyne is interpreting what the statute of 13 Elizabeth means by the intent to hinder, delay, or defraud. and he gives what are known as the badges of fraud. If this happens, or this happens, it's probably fraudulent. And those badges have actually been incorporated into the fraudulent transfer statutes, but courts will refer back to Twyne's case for that test.
I see. So you've solved the mystery, or at least most of the mystery of Twyne's case. What's coming next? What are you tackling next in your history of commercial fraud?
Well, other than writing an article about a rather amazing marine insurance fraud that allegedly occurred in Livorno, Italy in 1608 and 1609 and involved insurers in Amsterdam, Antwerp, Genoa, and London, among other places, I am working to turn my study of English commercial fraud into a book. I think everybody would admit that we have a fraud problem today. And I think that if we're going to understand that problem, we need to stop imagining that fraud is a modern problem and that the past was some kind of golden age of upright and honest merchants, because it wasn't. People are selfish and greedy, and they've always been selfish and greedy. And I want to show that the motivations for committing fraud, and even many of the frauds themselves, were basically the same in 1570 or 1620 as they are today.
It's a wonderful project. We'll have to have you back on when you finish either the article or the book.
Good deal.
Thank you for joining me. And that's our show for today. If you like what you heard, please subscribe and rate us on Apple Podcasts. Thank you for listening. I'm Jim Speta signing off.
If you'd like more information about today's show, please visit law.northwestern.edu/planetlex or LegalTalkNetwork.com. Subscribe via iTunes and RSS. Find both Northwestern Pritzker School of Law and Legal Talk Network on Twitter, Facebook, and LinkedIn. Or download the free app from Legal Talk Network in Google Play and iTunes. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Northwestern University, Legal Talk Network, or their respective officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.